I wrote Abuse of Discretion to solve the puzzle of Roe versus Wade. Why and how did the Supreme Court produce a decision that is so controversial 41 years later? I mean, by any objective standard, Roe versus Wade is the most controversial Supreme Court decision since Dred Scott in 1857, the decision which heightened North-South tensions leading up to the Civil War. Well, the conventional history of Roe versus Wade is that it was, quote, considered with special care, unquote. That's what Justice Powell said in 1983 in the Akron decision. And in Planned Parenthood versus Casey in 1992, Justices O'Connor and Kennedy and Souter said that Roe, quote, was a reasoned statement elaborated with great care, unquote. Well, that proposition is no longer defensible based on the record that we have today. The papers of several of the justices have been released over the last 10 or 15 years. And based on a review of those papers, Abuse of Discretion tells the story of the mistakes made by the justices and the unintended consequences that we're still living with today and that women are still living with today. Of course, what we call Roe versus Wade, what the culture commonly calls Roe versus Wade, is really two decisions, two cases from two states, Roe versus Wade from Texas and Doe versus Bolton from Georgia. And you can't really understand our national policy on abortion unless you read the two of them together as the court instructed. In Roe, the court suggested that the states could prohibit abortion after fetal viability, quote, except where it is necessary for the preservation of the life or health of the mother. But then in Doe, the companion case, the justices defined that health exception as, quote, all factors, physical, emotional, psychological, familial, and the woman's age, relevant to the well-being of the patient, unquote. That's why health in abortion law for the last 41 years has meant emotional well-being without limits. And that health exception in Doe swallowed the supposed ability of the states to prohibit abortion after fetal viability. So Roe and Doe together were sweeping decisions. And I was shocked by other things that I found in the justices' papers. First and foremost, Roe began as a procedural mistake. The justices took the two cases in April of 1971 from Texas and from Georgia, not to decide the abortion issue, not to address the abortion issue, not to declare a right to abortion, but to address and solve this mundane procedural issue about the jurisdiction between the state and the federal courts. But then 5 or 6 months later, a crisis erupted in the court in September of 1971 when two justices retired within the space of a week. Justice Black and Justice Harlan, who I argue probably would have voted against a right to abortion, retired within the space of a week due to ill health. Black died a week later. Harlan died at the end of 1971. That flipped the balance of the court, reduced the number of justices to 7, and it empowered a temporary majority of 4 justices, Douglas, Brennan, Stewart, and Marshall, to use the two cases to sweep away the abortion laws and declare a right to abortion. Without those twin vacancies, Roe versus Wade might never have happened, or at least come out the way that it did. And that's how the justices ended up with two cases with no trial, no evidentiary record on abortion or its implications. Because they took two cases that decide the jurisdictional issue, which wouldn't have needed a record or a trial on abortion. But when the 4 justices decided to use the cases to declare a right to abortion, they chose 2 cases with no trial or evidentiary record on abortion whatsoever. Well, compare that with what Justice Brandeis once wrote in 1927 in a case called City of Hammond versus Shappy Bus Line. Brandeis wrote for a unanimous Supreme Court, quote, before any of the questions, which are both novel and of far-reaching importance, are passed upon by this court, the facts essential to their decision should be definitely found by the lower courts upon adequate evidence, unquote. So without any evidence, untethered from a factual record as judges need to be, the justices in Roe were susceptible to novel theories of history, of law, and of medicine. And to give one example, the outcome in Roe was driven by the medical myth that abortion is safer than childbirth. And there was no reliable data in 1971, 72 to find that abortion was safer than childbirth. No existing obstetrical textbook in 71 or 72 made such a claim. But based on that medical myth, the justices prohibited health and safety regulations in the first trimester when 90% are done, and created a public health vacuum that we see most starkly in Kermit Gosnell's clinic in Philadelphia and Stephen Chase Brigham's clinics in Maryland and New Jersey and Pennsylvania. Then, after the cases were argued twice, and only a month before they were released, the justices arbitrarily adopted a viability rule that was never briefed or argued. The cases were, as I said, argued twice in October of 70, or December of 71, and then again in October of 72. But in 4 hours of argument, the word viability is not mentioned once. And you can see this for yourself, hear it for yourself, if you go to the website oyez.org, oyez.org. And you can hear the original audios in the case. You can read the transcripts of the arguments. And viability is not mentioned even once. Listen to the original argument, the starting argument by the Texas Assistant Attorney General in Roe versus Wade, and you'll just be astonished and dumbfounded by the way the Texas Assistant Attorney General started the argument, and it went down from there, unfortunately. And there are various pieces of evidence in the papers that indicate that some of the justices didn't really understand what they were unleashing on the country. Some are in the book, Abuse of Discretion, but here's one additional piece of evidence. This is a letter dated March 16th, 1973, that's 7 weeks after the decisions were released, by Justice William O. Douglas to Chief Justice Burger. And he is telling Chief Justice Burger that he's not going to vote to hear a particular abortion case because he said, quote, "Our decisions in Roe versus Wade and Doe versus Bolton were confined to 2 conditions. First, that the abortion, if performed, be done in the first trimester. And second, that it be based on an appropriately safeguarded medical judgment," unquote. That's what he thought Roe versus Wade meant in March of 1973. So here are 3 reasons, I think, just to sum up, for why Roe remains so controversial beyond the sheer numbers of abortions and children killed over the last 41 years. Roe is way out of line with international standards. Roe isolated the U.S. as one of only 4 nations, along with China, North Korea, and Canada, that allow abortion for any reason after fetal viability. Roe is way out of line with American public opinion, which supports abortion only in certain circumstances early in pregnancy. And American tort law and property law and criminal law have rejected the viability rule, which the court has imposed on the country for 41 years. The states have moved ahead with legal protection for the unborn children. We now have half of the states in this country with fetal homicide laws that extend from conception, and a total of 36 or 38 states with fetal homicide laws. Well, today I think that public opinion, public support for Roe is largely based on fear. The fear that overturning Roe, by overturning Roe, the court would make abortion immediately illegal. But the irony is that if Roe was overturned today, abortion would be legal in 40 to 45 states tomorrow, up to 20 weeks or up to fetal viability, for the simple reason that there are no abortion prohibitions on the books in those states, or that the state courts, because of state decisions, would prevent them from being enforced. The justices have assumed the self-appointed role of the National Abortion Control Board, but they can only monitor the situation in clinics by hearing cases. And they have repeatedly refused to hear cases. So they can't justifiably, responsibly, even assume that role and monitor it without hearing cases. Well, these are just some of the mistakes of Roe versus Wade that I set out in Abuse of Discretion. But the question remains, why do the justices stick with Roe versus Wade 41 years later? Why do they stick with Roe today, despite all the controversy? Well, lawyers are familiar with the distinction between the holding of a case and the rationale of a case, the what and the why. The court's holding in Roe is that there was a right to abortion. And the court's why in 1973 was largely history. Well, the holding of Roe is still the law of the land today in some sense, but the court abandoned the original why and shifted to the reliance interests that Charmaine mentioned in 1992 in Planned Parenthood versus Casey. Abuse of discretion tells how the court got us into this mess, and the reliance interests are the key to getting out of the mess. So now I have the pleasure to introduce Anna Franzanello. Anna earned her bachelor's in history from Franciscan University in 2003 and her law degree from Notre Dame Law School in 2009, and she joined AUL full-time as staff counsel in 2009. Her areas of expertise include protecting freedom of conscience. She's authored multiple comments to the Department of Health and Human Services, addressing the inappropriate overreach of the HHS mandate and the insufficiency of the conscience accommodations suggested by HHS. She's also testified before the Institute of Medicine about preventive services, part of the Affordable Care Act. And her publications include Healthcare Reform and Respect for Human Life, How the Process Failed, which was published, co-authored with Bill Saunders and published in the Notre Dame Journal of Law, Ethics, and Public Policy in 2011. And as you might expect, she consults frequently with state and federal legislators. And I gotta say, I'm glad that Anna is on our side, because I'm pretty sure if I debated her about anything, I'd lose. Please join me in welcoming Anna Franzanello.